Hi, and welcome to our review of the Columbus Board of Realtors real estate purchase contract. We're just going to go through this purchase agreement so that you have a better understanding of the document. So this is the purchase agreement that was released from the Columbus Board of Realtors in September of 2024. So this does have some additional things in it that the old contract did not. So there are some changes. So we're going to also touch on those. But first, this contract is 16 pages long. The very first thing that you'll see at the top of each page is the property address. If you're using Autofill and Dotloop, and you fill in the property address that you're writing an offer on, when you do the autofill, it will fill in that field at the top of every page so that you don't have to manually do it. Next, the top of the document just explains here that it was prepared by the Columbus Realtors and the Columbus Bar Association and is for the exclusive use of their realtor members only. So the first thing that you come to is the date that you're actually filling out this purchase agreement. So if you're writing the offer on November 27th, 2024, that's what you're going to fill in here. Next is just some defining information on the parcel that you're writing an offer on. So the first box that you're going to come to is following described as being located in the state of Ohio, county of. So you're going to fill in what county the parcel that you're wishing to purchase is in. In this case, we're going to go with Fairfield County. Next, tax parcel numbers. You'll fill in the tax parcel number from the auditor site for that parcel here. This box can hold a couple of parcel numbers, so if you have a couple of parcels involved in the transaction, you can generally get 2 or 3 into this box. If you need additional room for additional parcel numbers, you can use section 1.1 additional terms and conditions. So after you fill in the tax parcel numbers, next it says, and further described as, this next box is the physical street address of the parcel. So you're going to fill in the mailing address or the street address here for the parcel. And then after that is another box where you're going to fill in the legal description of the parcel. If you have multiple parcels with multiple addresses, here you will fill in all of the information about each parcel. So this is basically just a triple check of we're all talking about the same parcel, right? So we're talking about this parcel in Fairfield County with this physical street address and with this legal description. So that gives the title company an easier way to double check what we're looking at. Next, section 1, purchase price shall be. This is where you're going to fill in how much your client is offering to purchase this property for. In this case, in this example, we're going to use $210,000. So purchase price shall be $210,000 in the first box as numerals, and then in the second box as written words. So $210,000, $210,000. Next, section 1.1, additional terms and conditions. This box is rather small, so it's meant to only fit a couple of things in here if you need it. This is where you would fill in the additional parcel numbers if you do have multiple parcel numbers that don't fit up top here. You can also fill in here any kind of relationship that the buyer or seller might have with the listing or the selling agent. You could also fill in here appraisal gap coverage, reference to an escalation clause. You could put here that the purchase is contingent on the buyer doing inspections and they agree to purchase as is. So those are the types of things that you can put in additional terms and conditions. You could also simply say, see attached additional terms and conditions. And then there is a form in Dotloop called attached or just additional terms and conditions. And if you need more space, this box is not big enough, you can use additional terms and conditions and just say here in 1.1, see attached additional terms and conditions and then include that other document with your offer. Next, section 1.2, this is new to this contract, buyer broker compensation. You no longer need to go dig for the clause that you need for a purchase if your buyer is asking for the seller to pay toward buyer broker compensation as a seller concession. So in this first box, it's asking who we're asking to be paid. So in this case, we're asking Key Realty to be paid buyer broker compensation. And then in this box, we're stating how much we're asking for. So if you notice to begin with, this box doesn't have anything in it, no percent sign, no dollar sign. So that means you can fill in the amount that is on your buyer agency form with your buyers. So if it's a flat rate of, say, I don't know, $5,000, you could say $5,000 here. or if it's a percentage of the purchase price, you could list that percentage here as what you would like the seller to contribute. Next, attorney approval clause. This just gives a set number of calendar days for the buyer or seller to have their attorney look over this purchase contract. By default, this provision doesn't come into play unless you fill something in the calendar days box. So like it says here, this provision is not applicable if number of days is not inserted. But if you put 5 days here, now this clause comes into effect, and buyer and seller shall have 5 calendar days after acceptance to have their attorney look over this contract if they would like. And that also allows them to terminate the contract if there is something that their attorney does not like. Next, Section 3, the new contract broke out how cash transaction versus financing looks on the contract. So you'll see here, if they are in Section 3 stating that they are making this purchase as a cash transaction, they're going to initial here that they're paying cash. And then next, they're going to initial that they are paying cash toward the purchase price at closing, and that Section 3.2 doesn't apply to this contract in particular since they're paying cash. It also states here that they have a certain number of calendar days. If left blank, number of calendar days shall be 5. So at a minimum, 5 days if they're paying cash to provide proof of funds or a letter from a financial institution, a current bank statement, something that reasonably satisfies the seller that they do have the cash available to make this purchase. 3.2 states that the buyer is using some kind of financing in order to make this purchase, so they will initial here if they're using financing. And then in 3.2a, they're going to initial in either here, stating that the pre-approval that they have was included with this offer to purchase, or they're going to initial here, stating that the buyer will deliver a pre-approval letter to the seller within so many calendar days. If they choose to go with we'll deliver it after the offer is accepted, by default, they have 2 days to get that letter to the seller. If you leave it blank or you fill in what you need to fill in here, say for this example, I'm going to say we need 5 days to provide that information. So I'm going to put 5 days in there. Next, 3.2b, the loan application process itself. This is just stating that within so many calendar days, your buyer will go make a full loan application with the lender that they have mentioned in the pre-approval letter that is included with this purchase, with this offer to purchase. This, by default, is 7 days. So if you don't fill in anything here, they have 7 days to do a full loan application, or you can fill in whatever amount of days here that you need. Typically, I use 3 calendar days, unless maybe there's a weekend involved, and then I might change it to 5. Next, in Section 3.2ba, we're going to write what kind of loan this person is getting. So if they're getting an FHA loan, we're going to fill in FHA. If they're getting a hard money loan, fill in hard money. If they maybe already own property and they are taking out a home equity line of credit in order to purchase this property, then you would fill in HELOC. This does also require that the buyer inform the seller or seller's broker in writing of the identity of the lender, and does also lay out some expectations for the buyer that they will do the things that are being asked of them to continue this process and not hinder the financing process. And if for some reason that the process is not going smoothly, the seller is able to terminate the contract. Section 3.2c, loan commitment. This is stating that the seller's obligations are contingent upon the buyer obtaining and delivering to the seller or seller's broker a loan commitment within so many calendar days. And if this one is not filled in, it's not applicable. So if you don't fill in anything here, it doesn't apply to the contract. This is typically 3 days prior to closing. So if you're closing in 30 days, you might put 27 days here. But this clause basically gives the seller the right to terminate the contract if they do not feel that the buyer in good faith is doing what they need to be doing and making reasonable efforts to obtain the loan in order to purchase property. So you would fill in whatever applicable number of days there. 3.2d, this is a new portion of the contract. Well, appraisal contingency is not new, but whether or not the contract is contingent on the property being appraised by a licensed appraiser at no less than the purchase price, you will simply choose the contract is or is not contingent. In most cases, unless it's a cash transaction, the purchase is probably going to be contingent on an appraisal. This goes on to state that if the property was appraised and it does come back underneath the purchase price, that the buyer and seller then have 5 days to renegotiate or terminate the contract, depending on what is decided. 3.3, demand for financing evidence. This just states that if the seller is not reasonably satisfied with the information provided to them in section 3.1, 3.2, the financing evidence section, then they, up until 7 calendar days before the closing date, may notify the buyer or buyer's broker in writing that the seller has not received the required financing evidence, and that will potentially allow them to terminate the contract. It does say that once the seller reaches out and says we don't have that information, there are 3 calendar days. Yeah. They have 3 calendar days to provide the information requested, or else the seller may terminate the contract. Section 4, taxes and assessments, just states that the seller of the property is going to bring taxes and assessments current by closing. So what does that mean? And this is where the title company gets involved. The seller is responsible for paying any property taxes or any other assessments against the property prior to closing, and will not become the buyer's responsibility once they close. Section 4.2 talks about a community development charge, if applicable. This is where you would list if there's a homeowners association, a condo owners association, a property owners association, or anything involved with this property. So in 4.2, you're going to say what county the HOA requirements, bylaws, and declarations are recorded in, what volume number in the recorder's office, what page number in the recorder's office, or if it's certain counties, like Franklin County uses instrument numbers, you're going to fill in the instrument number of the HOA bylaws and declarations packet here. 4.3 just states that the seller warrants that no improvements or services have been installed or furnished, nor notification received from public authority or owners association of future improvements of which any part of the cost may be assessed against the premises, except the following. So say something just has not hit the property as far as an assessment, and the seller knows that it's coming, so perhaps they might fill that in, or would list that in the MLS listing that needs to be taken care of. So section 5, fixtures and equipment. This is what's included or not included in the sale of the property. There is a handy list here of things that are typically included, typically convey in a sale without needing to be mentioned. If what you are looking for is not mentioned here, then you can put other included equipment or fixtures not listed above, or none if nothing inserted. So I'm listing all appliances, the window coverings as seen at the showing that we had on 11/27. 5.2 is the following shall be excluded. So if there is something in particular, a pool table is a good example. Maybe your buyers don't want the pool table. You could specifically exclude it so that the sellers need to remove it prior to closing. And then you're going to also fill in as seen on and your showing date. And this is up here is the old way of doing it, and I'm used to doing it that way. So this is a change in this contract where you can fill in the month, day, and year of when you saw the property so that we know that the property was in a certain condition on that day. 5.3, the following leased items shall be included. So here, leased items are typically a water softener, a set of solar panels, a propane tank. So you can list that item here if it is leased, or if it is leased and you want it excluded. Solar panels, again, is a good example. We don't want the solar panels, so if you could not include that in the purchase, you would list that here. Same with maybe a water softener and alarm system. Anything that is leased and the buyers don't want to pick up that lease once they close, then you can list that here. Section 6, inspections and tests. This is the section that allows your buyers to make a purchase contingent on their inspection and satisfaction of that inspection on a property. So this goes on to say that the buyer may only terminate this contract for material defects, which includes, but is not limited to, those defects or conditions which impact the health, safety, habitability, use, or value of the property. Buyer may not terminate this contract agreement for non-material conditions such as routine maintenance and cosmetic issues. So, starting out first with the purpose of the inspection period. Also goes on to say in 6.2 that the seller shall cooperate in making the premises reasonably available for these inspections and or tests. All utilities shall remain on until possession is delivered to buyer, except utilities that were turned off at the time of showing. So basically, if the water was turned off at the time of showing, then you may not be able to test the water during inspection. However, you could put in the additional terms and conditions above that all utilities to be usable at the buyer's cost in order to do a home inspection. It also says that a buyer acknowledges that buyer and other professionals are not authorized to be present on the property without a real estate licensee unless prior expressed written authorization is given by the seller. 6.3 specified inspection period. This is where you're actually going to state how many days you need for an inspection period. This one is one of those boxes that's not applicable if you don't fill in anything here. So if you don't fill in a number of days here, then the inspection period contingency does not exist. So if you're going to want 10 days to do inspections, you're going to fill in 10. And that is the number of days that your buyer is going to have to do any and all inspections and have reports back by the end of that 10th day. Going on to the next page, it goes on to lay out all of the different types of inspections that the buyer is allowed to do at their own expense and is strongly encouraged to do these inspections. A regular home inspection, a radon test, mold, or any other environmental test, lead-based paint, termite and wood-destroying insect inspections, inspection of gas lines, the water treatment systems if there's a well or septic involved, assessment of special flood hazard areas, those types of things. So your buyers are able to do all of those inspections at their own cost. 6.4 states that if the buyer is not in good faith satisfied with the condition of the premises as disclosed by the buyer's inspections, tests, and reports provided for in paragraph 6.3, then the buyer may elect to proceed under one of the following provisions. So 6.4a, agreement to remedy period. On or before the end of the specified inspection period, the buyer shall deliver to the seller or the seller's broker a written request to remedy signed by the buyer stating the unsatisfactory conditions, along with a written copy of the inspections, tests, and or reports, if any, specifying the unsatisfactory condition. So this is where you're going to fill in after your inspection period how many days you and your buyer would like to have to renegotiate with the seller should something unsavory come back in the inspection. Again, this is something that if you don't fill in anything in the box here, this section doesn't apply. So you could potentially have an inspection period of 10 days, but then not fill in anything here. Basically stating that we want to do inspections for our own knowledge, but we're not going to come back to the seller and ask for anything in particular. Or you could fill in, say, 3 days here and say, yeah, we're going to do inspections. We have 10 days to do that. And at the end of that 10 days, we would also like another 3 days to renegotiate some things if need be. Doesn't mean anything's going to need to be renegotiated. Just means that you have time built into the contract in order to do that. 6.4b, notice of termination within the specified inspection period or as provided in paragraph 6.4a. The buyer may terminate this contract by delivering written notice of termination to the seller or seller's broker, along with a written copy of the inspections, tests, and report specifying the unsatisfactory conditions. Upon termination, the earnest money deposit shall be returned to the buyer pursuant to paragraph 12. So yes, that basically states that if the buyer is not satisfied and we can't come to terms after renegotiating or talking about it, then the buyer has every right to terminate the purchase agreement based on the inspection. But it does state here that if the buyer is unable or unwilling or just doesn't deliver written notice pursuant to paragraph 6.4a and b, that does mean that the buyer has accepted the condition of the premises and would like to move forward. So after that inspection period, if the buyer doesn't say anything to the seller or seller's broker that, hey, we're not satisfied with this at the end of the inspection period, then we're moving forward. 6.5, condominium and homeowners association document provision. This talks about if the premises is a condo unit governed by a condominium association or is located within a community governed by a homeowners association, the seller shall provide buyer with the following information and documents within 5 calendar days after the date of acceptance of the contract by both parties. So this is where your buyers are allowed to review the HOA or COA the owners association declaration of deed restrictions, bylaws, and they will have 5 days to provide that. The seller has 5 days to provide that information. Also, the managing board, the management company, their contact phone number and email, any contact information for anybody else that is on the membership board, anything having to do with meetings, the agendas, the meeting minutes, anything to do with an association initiation fee, a reserve contribution, or association transfer fee, minutes from the last 3 meetings of the board of directors or trustees, minutes from the last meeting of members of the owners association, most recent version of unrecorded rules and regulations, and current financial statement showing the nature of the association's assets. So that information can be requested by the buyer from the seller, and then the buyer shall have 5 calendar days after receipt of the last delivered document or 10 calendar days after the date of acceptance of the contract by both parties, whichever shall first occur, in which to review the documents. If the buyer is not provided with those requested documents or is not satisfied with the documents they received within the stated time period, the buyer may deliver a written notice of termination to the seller, and the earnest money shall be returned to the buyer pursuant to paragraph 12. So, again, if the buyer gets a copy of the bylaws and declarations for the homeowners association or the condo owners association and just doesn't like things that they see in there, and they're still within that 10-day period, then they are able to terminate the contract based on the documents provision of this contract. Section 7, warranties, home warranties. So they did expand on this a little bit. Home warranty or protection plan, the buyer selects or does not select. So your buyer actually needs to say yay or nay here instead of just leaving it blank like we used to. So we're going to say the buyer selects or does not select a home warranty to be provided by, and this is the home warranty company. So I filled in APHW, America's Preferred Home Warranty here, and paid for, and then you're going to select who's paying for it, the buyer or the seller. And then how much are they paying for this warranty? And then it does state the broker may receive compensation for services rendered in connection with the sale of the home warranty, just saying that your agent might get paid for selling a home warranty. Section 8, the deed. This just says that the seller shall convey to the buyer marketable title and fee simple by transferable and recordable general warranty deed with release of dower, if any, or fiduciary deed as appropriate, free and clear of all liens and encumbrances, not accepted by this contract, and accept the following. So then lists a couple of things that doesn't cover. And then section 8.2 goes on to state that as far as the seller knows, they have not transferred, conveyed, or reserved, nor does seller have any knowledge of any prior transfers, conveyances, or reservations on any timber, coal, oil, gas, or other mineral rights or interests in the premises, except for the following. So if you do, for example, have something where the seller has sold their rights maybe to something, a mineral right or something, you would list that here, stating that it's not included in the bundle of rights and doesn't convey. Section 9.1 is Section 9 is title insurance, just stating the seller shall furnish and pay for an Alta homeowner's commitment and policy of title insurance in the amount of the purchase price with a copy of the subdivision or condominium plat. So just stating that the seller is going to provide title insurance, and that will come from their title company. And that 9.2 goes on to state that seller shall deliver or cause to be delivered, meaning the title company is going to send it, a copy of the commitment referenced in 9.1, the title commitment, no later than 15 calendar days prior to the date of closing pursuant to this agreement. So this agreement is closing on December 31st in this example. So we would expect a title commitment and title policy commitment probably by the 16th of December from the title company. Section 10, utility charges, condominium charges, interest, rentals, and security deposits. 10.1, through the date of possession, all utilities shall remain on, except utilities that were turned off at the time of showing, and the seller shall pay all accrued utility charges and any other charges that are or may become a lien on the premises. So basically, the seller, until they actually sell the property and the buyer takes possession, needs to maintain the utilities as they would, as if they lived there, and they need to keep the utilities in their name until it is time to transfer them out of their name. 10.2 talks about if this is a investment property or rental property, that the buyer needs to receive the interest on any mortgage assumed by the buyer. Adjustments shall be made through the date of closing for rentals, interest on any mortgage assumed by the buyer, and condominium or other association periodic charges. So basically, if you're paying like a condo owners association monthly fee, that will be prorated to the seller and buyer so that they're paying the appropriate fees based on their ownership time. 10.3, if this was an investment property or a rental and is currently rented, security deposits for those tenants shall be transferred to the buyer. 10.4, at closing for condo properties or properties subject to a homeowners association, buyer shall pay all initial reserves and or capital contributions that are charged by the owners association or civic association in connection with the sale or transfer of the premises, as well as any fee associated with lender required document costs. Seller shall pay all other fees that are charged in connection with the sale or transfer of the premises, including without limitation all transfer, processing, expediting, delivery, statement, or management company fees. So this basically says that the seller is responsible for the fee that the HOA might charge to transfer owners on a property, or any kind of processing that that HOA may have in order to do that. But say there is maybe a join fee or a reserve or capital contribution fee that your buyer is going to have to pay in order to join the HOA, your buyer is responsible for that unless otherwise stated in the contract. 11, damage or destruction of property. Risk of loss to the property and appurtenances occurring prior to closing shall be borne by the seller. So basically, if anything happens to the property while it's in contract, the property should be returned to the state that it was in when it was put in contract. 11.2 goes on to say that if a part of the property covered by this contract was substantially damaged or destroyed from the date of written acceptance of this contract through the date and time of closing, the seller shall give written notice to the buyer about the damage or destruction, and should include any pertinent information regarding insurance policies, claims covering the property, that kind of thing, and either agree to extend the closing date in order to restore the property to its previous condition. We can also accept the property in its damaged condition with an assignment of insurance proceeds if there are any available, or terminate the contract by giving written notice to the seller or seller's broker. 11.3, failure by the buyer to notify the seller and or seller's broker in writing within 10 calendar days from receipt of the damage means that they are electing to proceed. 11.4, failure by the seller to provide the required written documentation to the buyer or buyer's broker shall result in the buyer, upon discovery of the damage or destruction before closing, having all rights set forth in paragraph 11.2. So basically just saying that they will be able to proceed, but the seller may not be entitled to insurance proceeds or anything like that if they did not let the buyer know. It also states in 11.5 that if the buyer discovers the damage or destruction after closing, the buyer shall have the right to pursue all legal remedies. Section 12, earnest money. Earnest money has not changed much here with the new contract, but you will, 12.1, fill in the amount that we are depositing for earnest money. 12.2 is going to have your buyers choose how they want to deposit the earnest money. Do they want to do it within 3 calendar days of acceptance of this contract, or do they want to do it not later than 3 calendar days after the expiration of the agreement to remedy period? So depending on how they choose, they're going to either initial here or here. 12.2a just states that within 3 calendar days of the receipt of the earnest money, the buyer or buyer's broker shall notify the seller that it was received. If the seller or seller's broker does not receive the deposit notice within 3 calendar days following the date set forth in paragraph 12.2, seller may at any time until seller or seller's broker has received the deposit notice notify buyer or buyer's broker in writing the seller has not received. If the seller doesn't receive it within 3 calendar days, the party can proceed if it is received within 3 calendar days. If not received within 3 calendar days after delivery of the deposit notice demand, buyer will be in breach of the contract, and seller may, at any time thereafter until the deposit notice has been delivered, terminate this contract. So if we don't deposit the earnest money, the seller has every right to terminate the contract. 12.2c just states that upon receipt of the earnest money by the broker, the earnest money shall be deposited into the broker's trust account. And then here is where someone at the brokerage, the buyer's broker or the holder, might be a title company or something like that, will acknowledge that it was received and how much, the check number, and when. There is a set there typically up here. We'll go back to 12.2 for just a second. If you'll notice here, it does say buyer's broker / holder. So now, because Key does not hold earnest money, this is where you typically would strike out buyer's broker and fill in title company. But now it says buyer's broker / holder. So you don't have to actually strike out anything up here now. 12.2d just goes on to explain how or why or when earnest money might be released and who it might be released to and why and what happens in what situations. Just make sure to read through this so that your buyers understand at what point they may or may not get their earnest money back. 12.3 is new to this contract. This is the holder of the earnest money. Like I mentioned a second ago, you don't have to strike out buyer broker anymore because it says buyer's broker / holder. If it is being held by someone else, like the title company, this is where you're going to fill in that, for example, United Alliance Title is holding the earnest money. And then your buyers will fill out and sign an escrow agreement to include with this offer that will go to United Alliance Title once the offer is accepted. Section 13, additional provisions. This is just a set of term definitions. What does buyer mean, seller mean, parties, contract? But the one that I want you to pay close attention to is days. Always in this particular contract means calendar days, including holidays, and also references the Eastern time zone. Date of acceptance of this contract is another one that's kind of important, or any counteroffers, amendments, or modifications thereto shall be when the final writing is executed by all necessary parties and is delivered to the offering party or their broker. So days after acceptance starts at 12:01 a.m. the first day following the date of acceptance. So if you signed the contract accepted today, then all of your timelines start tomorrow at 12:01. 13.1 just says that this is the entire agreement, the entire contract, that there are no representations, oral or written, which have not been incorporated into this contract, and anything going forward that needs incorporated into the contract will be made as a contract amendment and will be made in writing and signed by all parties involved. 13.2 is time is of the essence clause, just stating that if something needs to be done by buyer, seller, title company, you, the agent, whatever, that it needs to be completed quickly. 13.3 just states that all representations, covenants, and warranties of this part of the parties contained in this contract shall survive the closing. 13.4 signatures, and pretty much any signature is allowed with this contract. 13.5 just is the signed, sealed, and delivered paragraph, just stating that things are not in effect until they are delivered. So notices delivered in connection with this contract shall be effective upon delivery of the other party. 13.6 is the Foreign Investments in Real Property Tax Act, or FIRPTA. You generally only need to worry about this if you're working a lot with investments, or perhaps a foreign person, as this mentions, a non-U.S. citizen. If you do get involved with something like this, the title company should be able to help. Section 14, notice to the parties. 14.1, professional advice and assistance, just stating that there are some things that you as a real estate agent aren't able to help with, but you are able to help your client find the appropriate person that could help with something if you aren't able to. 14.2 just says that we comply with Ohio Fair Housing Law. 14.3, property disclosure forms. This is a new box here that actually makes receiving the property disclosure form a contingency of the contract. So you're going to stay here in 14.3a, buyer has or has not received an Ohio residential property disclosure form or an exemption form completed by the seller. And then it goes on to state so this section goes on to say that if you have not, as if your buyer has not received satisfactory property disclosure form, that the buyer may be entitled to rescind this agreement by delivering a document of rescission to the seller or the seller's broker, provided such document of rescission is delivered prior to all three of the following dates: the date of closing, 30 days after the seller accepted the buyer's offer, and within 3 business days following the receipt by the buyer or the buyer's broker of the property disclosure form or amendment of that form. So pay close attention to that. Make sure that your buyer did receive a property disclosure form and that they did sign it. Next, 14.3b, your buyer is just acknowledging that they did receive the seller's disclosure of any lead-based paint or lead-based paint hazards known to the seller on the property, if applicable, and if home is built prior to 1978. So you check here, buyer has not, or if the property doesn't apply, the lead-based paint disclosure law doesn't apply to this property, you could check not applicable. Same with the next one, buyer has not, or not applicable, received the pamphlet, Protect Your Family from Lead in Your Home. 14.4, Ohio Sex Offender Registration and Notification Law, just stating that we can't do that research for our client, but we can point them in the right direction to find that information, and that information disclosed may no longer be accurate, and that the buyer assumes responsibility to obtain that accurate information from the sheriff's office. 14.5, concessions, just stating that buyer and seller authorized the broker to report sales and financing concessions data to the MLS membership and the MLS sold database as applicable. 15, closing and possession. Closing, this is the date that closing should be performed by. So I'm choosing 12/31 because it's about 30 days away. And then it goes on to talk about release of dower notices. So 15.1a just gives you a couple of notices for seller dower notice and buyer dower notice, that if seller is married or seller's spouse is not a party of this contract, seller acknowledges that seller's spouse will be required to sign a separate release of their dower interest in the property in the form of a deed no later than the date of closing. Same applies for the buyer. Buyer acknowledges dower or other spousal rights may require a signature of buyer's spouse, even if buyer's spouse is not on loan or title deed, and that if they have any questions, they should talk to an attorney. 15.2, final verification of condition. If you leave this one blank, it defaults to 2 days prior to closing, but this is the number of days prior to closing that you want your buyers to be able to walk through the property and just double check that the condition is what they expected it to be. 15.3, possession. Seller is entitled to possession through. I know typically we just fill in closing and funding here if they are getting possession at closing, but this should actually be a specified date and time that the key exchange will happen. So closing I have set to December 31st, but I'm going to say December 31st at 3 p.m. is when we're going to do the key exchange. Now, if closing changes, then you need to remember to also update possession if possession is going to change. So make sure that you remember that. 15.4, debris and personal property. Property shall be at a minimum broom swept clean, and seller shall remove all debris and personal property not included in this contract by the date and time of buyer's possession, unless otherwise agreed to in writing. So basically, anything not included in this purchase agreement shouldn't be at the property when buyers take possession, and the property is expected to be in a reasonable broom swept condition. This paragraph goes on to state that if the seller fails to comply with this paragraph, any personal property debris remaining on the property shall be deemed abandoned, and the seller shall be liable to buyer for all reasonable costs associated with bringing the property to broom clean condition and or removal or disposal of seller's personal property and other debris. So this basically goes on to say then if there is anything left over, say I used the pool table as an example a little bit earlier, say you specifically excluded the pool table and now buyers took possession and now the buyers have to pay someone to remove that pool table, the seller could be liable for that additional cost. 16, duration of offer. This is how long is this offer open for acceptance by the seller once you submit it. They did change this box around a little bit, making it easier to fill in information. You're going to choose your date. I'm going to say by tomorrow, the 28th at 9 p.m. Section 17, buyer and seller actions. This is new for this contract as well. 17.1 states what the action by the buyer is. As a buyer, it is important to read and understand this offer before signing below. By signing below, buyer fully understands and approves this offer, is of legal age and capacity, has the authority to enter into this contract, and that any and all additional signatories, including that of a spouse or otherwise, who are necessary in order to purchase the property or obtain lender financing, have agreed to sign such required purchase and or financing document. Dower or other spousal rights may require signature of spouse, even if spouse is not on the loan. Same thing goes for action by seller. 17.2, as a seller, it is important to read and understand this offer before signing. Seller represents that seller read and fully understands this offer, is of legal age and capacity, has the sole and complete authority to enter into this contract and to sell the property, and that the consent or approval of any other person or entity is not required. And then finally, page 16 is the signature page. This is where you're going to have your buyers sign. They're going to sign. You also need to fill in their printed name and the date that they have signed. You can also fill in their address, their phone number. If they do have an attorney, you can fill that in here. And then you're also going to fill in your brokerage information. So what brokerage do you work for, our license number, our MLS office ID from the MLS, our phone number, address, and then your information as the agent. So your name, your license number, your phone number, your email address. And then the same goes on the other side for the seller. You're going to want to maybe fill in the seller names, and then you're going to want to fill in the listing agent's brokerage information. Same as you would for your side, you're going to fill in their information. You can find all of this information in the MLS on each listing. Same with their license number and their contact info, all can be found on the MLS in that listing. And then at the very bottom, this is not, if you're the one making the offer for your buyers, you don't so much need to worry about receipt of offer. But if for some reason you submit an offer and maybe the seller doesn't accept it or doesn't even entertain it, doesn't want to proceed, the seller, you can expect the seller to return this document to you here with their signature stating here that they did review the offer, they received it, they did consider it, but signing here does not constitute any acceptance of the offer. So that's the entire Columbus purchase agreement, the new purchase agreement that was released in September of 2024. I hope this answers your questions and was helpful for you. And as always, if you have additional questions, concerns, or just need some additional help, please feel free to reach out to your regional manager. They would be happy to assist you, or you can send an email to agentsupport@keyrealtyagent.com.